going to record this. We're going to record this today for the folks who are unable to attend, and they can find the recording then, I think on Facebook, but also on our webpage. And I want to welcome everybody. I'm Pam Wycliffe, and I'm on the little committee who puts these together, along with Melanie Smith-Guillaume and Kathy Platt. And as you all know, there are things that I have to say before we even start. And one is that we end right at 1 o'clock. For those of you who have other things that you must do, I'd ask all of you to please mute so that we have a clear connection with everyone. Our general format is, excuse me, for our speaker to speak for a half hour and then have a half hour of question and answer. And Pat, if that is not what you would like, just let us know and we can change that. And however we do it, what we've been doing is having people put their questions in the chat, and then I can read those questions to you, or you can read them yourself, whichever's okay. I can read them to you, yeah, and you can answer the questions then as they came in.
Okay.
Okay, now I need to say that the League of Women Voters is a nonpartisan political organization. We encourage informed and active participation in government. We have a couple roles. One is voter services and citizen education. We present unbiased, nonpartisan information about elections, the voting process, and issues. And the second role is action and advocacy. We are nonpartisan, but after a study, we use our positions to advocate for or against certain policies of public interest. Saying that, any of the opinions that you hear today from our speaker or from anybody else are not necessarily the positions of the League. But by the members themselves. Finally, if you would like to know more about the League's positions on public policy issues, if you're interested in information about joining the League, go to our webpage, which is lwvsouthbend.org. And you will find also there the link to the Indiana and the National League for more information all about the League. I don't know about any activities that are coming up. I didn't see any of those. So if anybody wants to jump in and say something about anything, they can. Kathy.
Our annual fundraiser is Wednesday, October 27 at 7 o'clock on Zoom. And we will be giving our Making Democracy Work Award to Karen White, who I'm sure needs no introduction to any of you. And we will have entertainment, a couple monologues from area people. We will have music. We will have breakout rooms at the end. It should be a wonderful event. So please plan to attend. More information will be on our Facebook page and on our website. Thanks, Pam.
Thank you. Given that, I like to connect the League with our speaker, and today it won't be difficult at all, I don't believe. I want to say what the mission, the vision, and the value of the League is, and I got this from the website. The mission of the League of Women Voters of the United States is empowering voters and defending democracy. The vision is we envision a democracy where every person has the desire, the right, the knowledge, and the confidence to participate. And the value of the League is we believe in the power of women to create a more perfect democracy. And I don't think that'll be difficult to connect to our talk today, but I'm not sure. Our speaker today is Pat Hackett, who is the president of Hackett Associates, and she's an attorney, an adjunct professor of law at the Notre Dame Law School with advanced degrees in law and theology. She serves on the Indiana Supreme Court Committee on, I'm just reading this, You've probably all read it, but it's worth saying again. On character and fitness, she's an active civic leader with years of service in our community, including, in part, past board member of the YWCA, the Community Foundation of St. Joseph County, Memorial Hospital's Ethics Committee, past president of the Alzheimer's Service of North Indiana, and the Robert A. Grant Inn of Court. Pat is a current member of the Indiana Advisory Board of the National Immigrant Justice Center and the president of the law firm. Oh, and we know that she's the president of the law firm, Hackett and Associates. Whew. And now I'm going to let Pat talk about women and the Constitution. Thank you, Pat, for coming, and the floor is yours, or the screen is yours.
It's great, and thank you all of you for being here, and Pam for that warm introduction, and Melanie and Kathy, and all of you, Elizabeth, who were so involved in planning our time together today, and for all of you for making time. I want to begin by just saying that I truly love the League of Women Voters, and I don't use that word loosely. Your mission, as described by Pam, is essential to right relationship and the health of well-being, not only of this nation, but I believe creation itself. And you can sometimes think, oh my God, we're doing all of this, and does it have any impact? What you do does. I believe that. I am deeply an optimist. And so Pam gave an introduction to myself. Obviously, I think the helpfulness of a introduction is that it gives you a sense of the perspective which I bring to the conversation. And my work in the law as an attorney, my training in theology informs me. My own history informs me. Just as you hear my remarks, your own experience informs what resonates with you and what may not resonate with you. And I do take seriously, I do want to start by saying I take seriously that the League of Women Voters is nonpartisan, is welcoming of all, and really this mission of empowering voters and defending democracy. That's the perspective in which I speak. And I was talking to Melanie last evening, and I reminded her, and she said, yep, you always say this, but I'm going to say it again. In terms of my history, I grew up in a household that had both parties, and over my shoulder is my mom, who I revered, who was on the federal district court, a 1950 graduate of law school, who actually was appointed to the court by Ronald Reagan. And I am a lifelong Democrat, and vigorous political difference, but mutual affection and love of this country. So that's the perspective of which I'm speaking. I want to start by aligning what I am going to say with the mission of the League of Women Voters, empowering voters and defending democracy. So what I'm going to speak about today is difficult, I think, subject matter. It's very, I think, nuanced and focused. I'm not going to just give you a history of the Constitution with respect to women. I'm going to talk about what I think is most significant in our historical moment from my perspective as a practicing attorney, and what I think it means for women and the health and well-being of our country, and very much want to then open it up for questions. So part of knowledge, and we all know this, and part of defending democracy is knowing what is not working within democracy when democracy does not work. And that's why I said what I'll talk about, I think, is challenging material. Our democracy, obviously in our historical moment, does not always work well. And yet there are these beacons of hope and light and persons devoted to the spark that was in our founders, but yet unfulfilled in their own lives. And I'm a believer too, so I believe history is very purposeful. And it's not by accident that we're gathered here, for example, today. So as a lawyer and as a woman, I want to speak with you. If you read the description of my reflection, I'm going to talk about current 21st century efforts through the law, since that is my profession and one of my disciplines, to actually silence women, and thus, I believe, efforts to destroy our constitutional republic and the more perfect union to which we aspire. That is hard subject matter, but I do want to invite all of us, and we'll have conversation after, to really think about this and just know that's the perspective I'm coming from, and it's from a love of our country. And I believe shared values, regardless of political affiliation of those on this Zoom call. I want to put the conversation just briefly, very briefly, in historical context. And then I'll address 3 areas of the law where I see the silencing of women actively occurring. And then I'm going to give just a taste of a trajectory of a project I'm working on to rectify that. And this is a little bit more of my academic side, but I think it's helpful to know, and I invite your engagement with that. First, some history, an obvious point. Our nation's founders, if you read the Declaration of Independence, a quote, self-evident truth, self-evident, pay attention to that, was that all men are created equal. A lot of times we just read right through that. This is in our nation's Declaration of Independence. What is not in our Declaration of Independence, in our founding, and is still not in our Declaration of Independence, nor is it in our Constitution, and we know all the struggle around this, by an Equal Rights Amendment, is any, quote, self-evident truth that all men and women and the diverse spectrum of identities on that spectrum are created equal. That is not self-evident in our founding documents or in our current Constitution. That is extremely significant to our subject matter today. Of course, when our founders said all men are created equal, they even narrowed it more. They meant, for all their insight and spark of brilliance, they meant white men who owned property. Very important. That's relevant to today's court and the cases currently before this court and the efforts to silence women, if you bear with me, and we'll talk about that. And by all means, in the time for conversation and questions, if you take issue with anything that I say today, please feel free in a collegial spirit to articulate that and to follow up with me after if you think it's too much in a public setting and because of time constraints. I'd love to know your actual thoughts. So this is a very narrow understanding of all men, white men who own property. This is actually an oligarchical worldview. We hear that term oligarchy today thrown around. They reference Putin. Certainly, there are political leaders who've recently held office who share that view. An oligarchian worldview is consistent then, if you look at the history of our nation, with slaveholders, slave states in our nation's founding. Now, I know many of you are aware of this. You are either historians or students of history. You do know that many of the men who signed our Declaration of Independence and who were delegates at our Constitutional Convention actually owned other human beings. I just want to stay with that for a moment, because sometimes we have this rarefied, idyllic view of our founding. And I cherish our founding and the insights in our founding documents, and I believe contribute to history as a whole. But let's be real. Nearly 50% of those persons engaged in this owned other human beings, slaves. Our first presidents, 4 presidents, owned human beings. So what that means is bodily torture, enslavement, rape, as relevant to women today as we talk, were perfectly acceptable within that political order and fueled our nation's economy. But here's the point, and why I have hope, is those practices and that historical reality were not consistent with the political, theoretical, and jurisprudential roots of our nation in the Enlightenment, which started in France and in Europe and came to the new land. They are not consistent with in its commitment to individual freedom, commitment to dignity of all persons, not just white males who own property, but all persons and their inherent goodness and equality before the law, and the commitment to a pursuit of a good common to all. So lest we despair about honest discussion about our history, it is a both and, not an either or. And I am choosing to speak with you today, and I believe all of you, I bet, are involved with the League of Women Voters because you share what I just talked about, dignity and justice for all. And that spark was something shared by our founders, even in their brokenness, some more than others. If you read the letters of John and Abigail Adams, you know not all of them participated in that reality of brokenness in quite the same way. So in honoring that spark and their insight and honoring our future, we want to look at the beginnings of our country, but then also where are we in the 21st century? And that's what I want to talk about today, specifically from the perspective of women. How are we silenced under the laws of our nation? How are we not fulfilling the purpose and the destiny of this nation and our contribution to the broader global community? So there's a struggle from the beginning of our foundings. And I have another context, and I you know, the way I think about this, I like to sketch pictures. I'm not artistic, but I stick figures. I think of images. The one I think about here is that our constitutional republic, which is what we are as a nation, from the very beginning has really struggled internally, not only with this brilliant insight of dignity and justice for all under the law, but it's what I've sort of envisioned as this, and it's a harsh image, but it's like this three-headed hound of hell that has ripped at this nation from its foundings. And those heads, if you saw Harry Potter, those heads that hound are racism, misogyny, and greed. Racism, misogyny, and greed, which undermine our constitutional republic. We fought a civil war over this, obviously, but that struggle is not done. And we are in really a very critical point in our nation's history in the 21st century right now, where that struggle continues. And from a lawyer's perspective, I'd say the jury is out in terms of where we go from here. You know, after you try your case, you know this, the jury's out. We're waiting to see. And we have a role to play in this. Obviously, I don't need to talk about, it's too much to talk about today with respect to racism. That's too much, but it is very real, obviously. And I would just note, besides everything in the news that we're aware of and systemic racism in this nation, two very important court opinions from the Supreme Court in 2013 and then again in 2021, our US Supreme Court in two cases, Shelby County versus Holder, and then Baranovic versus the Democratic National Convention, gutted key provisions of the 1965 Voting Rights Act. That's important. I know as an organization, you're probably very aware of that. And we're at a point now to see, will we, in a bipartisan way, as a nation, will we pass voter protection laws? And obviously I'm mindful of John Lewis and his patriotism as I say that. Now, disenfranchisement of the vote has a long and storied history within this nation on both sides of the aisle. Just depends where you are in the point of history, on both sides of the aisle. And that is one way women are silenced, as well as people of color, based on economic bases and others. And when you combine that in our current moment with the 2010 case of Citizens United and corporate funding of the electoral process, this, what I've described as the hound of hell, is feasting right now. So this is a really highly charged legal as well as political moment for our nation. But I'm going to focus on women. And I think what's really important is, I think it's helpful, is to pay attention, not just to group folks together, but look at it and say, what is it specific to women? And how are they then dehumanized under the law of the United States? And how does that help the forces which undermine our constitutional republic? One of the way that happens to women is we are silenced. And I just a footnote here, it doesn't happen just in the United States. We are all watching in real time it happening in the Far East, in Afghanistan. Notice how significant the silencing of women is in Afghanistan right now. No women in political leadership, not educating women, removing women from the press, cloaking women in Black from head to toe to the point they disappear. That is not a phenomenon unique to the East. It happens in the West, in our nation. So how are women silenced under the law? Let me get right to it. I'm going to give you 3 examples that I believe illustrate how consistent this effort is in the present moment, never mind even history, the present moment to silence women in the law. I'm going to give you a procedural example of silencing women under the law. So how does the law procedurally silence women? I'm going to give you an example how women are silenced through a misapplication of our Constitution. And I'm going to give you an example through a misinterpretation of the Constitution. And then I'm going to just quickly tell you a trajectory. I can't get into it, it's too much time, of what direction could we go from here? What needs to happen from the perspective as a woman and as a lawyer to correct this? First example, procedural silencing of women. And I'm giving you this example, not assuming anything on your part related to abortion and abortion rights. You can be on either side of the aisle on this, or your perspective in terms of what rights should be with respect to women, but I'm going to give the example of Texas Senate Bill 8. That is an excellent example of a procedural silencing of women, which all of you as members of the League of Women Voters or as guests, I encourage you to be aware of. Because it's not always under the explicit law, it's the procedures associated with the law by which women are sidelined. So we've heard a lot about Texas Senate Bill 8. It's much in the news. It took effect September 1st. The US Supreme Court didn't stay it just Wednesday. The district court in the Western District of Texas did stay it. So it's going up to the 5th Circuit Court of Appeals. And that's in response to a lawsuit by the Department of Justice. Real quickly, what that law does is, in effect, it bans nearly all abortions, all of them. And that's regardless of the fact that pregnancy is a health circumstance, life and death for the woman, regardless of the circumstance. And it clearly is in contradiction to 50 years of Supreme Court jurisprudence, clearly in the 14th Amendment. And Texas knows this. And here's what I want to get to from the perspective of women. Texas knows it's unconstitutional, and therefore what they try to do is avoid federal judicial scrutiny by giving individual persons the right to sue. They even award them with a $10,000 payment if they're successful in their suit. And anybody can bring that suit. Now, what's really significant is the people who can bring the lawsuit don't have to be involved in the case at all. They can be a neighbor, they could be even a predator, they could be anybody, and they can bring this suit. And part of that is obviously because it's hard to stop the law when it's individuals. And Texas tried to say, well, it's not Texas, it's individuals who have this right. Department of Justice filed that lawsuit and stopped it. But here's what's relevant to us today: silencing women with that law. Think about that structure. What has happened with that law is that who has the right to sue? It's other people, neighbors, other people, who typically in the legal structure have no standing to even bring an action. And who do they sue? They sue medical providers, and they sue anybody who aids and abets an abortion. Here's the point about silencing. Look at the structure of the law. Who is the person who is not part of that structure at all? It's the woman whose health care is controlled and at issue. She's not a party to the lawsuit. She has no right to the legal action. She is completely silenced under that law in its structure. So It's a nuanced point, but it's so important when we understand the coercive power of law. I'm engaged, I have a license in a profession that is very coercive in its use of power, and it can pursue justice or not. And my point is, the person whose life is most impacted health-wise is silent in that. That's a procedural example in the 21st century of the silence. And Indiana and other states are considering applying that law as well. Make sense in terms of the procedural? Okay, now, one of the architects who created that law, just so you know, he said he called it an exquisite use of the legal process. Wow. I'd say it's clever from a theological perspective, and I know who I identify with clever. And that's what he says it is. Now, I think it's an incredible coercive force silencing women, regardless of the underlying abortion debate, just the use of the law itself. And that's why, if you look at, and I encourage you to read the district court's opinion, it's very long. It gives a lot of attention to the actual voice and experience of women who are impacted by the law, because I think the district court understood the silencing of women. Let me go to a second example of silencing women under the law. Okay, that's a procedural one. A second one in the 21st century that I observed as an attorney in an effort by the law to silence women, which I'm very aware of. And I'm also concerned about this because of my theological training and my pastoral work, as much as my legal training. So this critique is not because I am not a person of faith. It's exactly because I am that I'm very concerned about this, is that there is an effort to silence women through a misuse of a constitutionally protected right, and that is religious freedom. It's enshrined in our Constitution in the First Amendment. And that right is being misused to harm and silence women and religious minorities, I'd add, and sexual minorities as well, such as LGBTQ citizens. And so I think it's terribly important. Even rights that we have can be misapplied to the detriment of women. Now, how is that happening? Well, it actually began in the 20th century. We're at a point right now in 2021 where we are post the Federal Religious Restoration Act. All right. And that was the federal law in 1993 that's been adopted by a lot of the states. And by the way, that was bipartisan, big support of that law, both sides of the aisle of RFRA. But what that law does is it imposes a super strict scrutiny and a framework on what would otherwise be neutral laws, generally applicable to all. And it favors disproportionately, when you look at its application, it really favors religious institutions. And as we know in the West, those religious institutions are primarily religious institutions that are patriarchal. They're men's institutions. Instead of the civil liberties of believers, their individual right to religious freedom, and non-believers alike. Okay, so RFRA, people just right now in 2021, we're here sitting here thinking, oh, that's just part of the statutory scheme of the United States. Actually, that statute is being used to distort traditional First Amendment jurisprudence on religious freedom. And I know I'm sort of getting into the deep into the weeds here, but I think it's, I mean, our purpose is education and our purpose is to understand this. What all I'm saying is, look, I gave you an example of a Texas law procedurally sidelined, didn't end run around the Constitution. Now I'm giving you an example of through a statute that has the same effect of sidelining and harming women, both at the federal and state level. How? By changing the jurisprudence and the very balanced jurisprudence in religious freedom that was under a constitutional at our founding. Actually, I think our founders got it right on this one, because in the First Amendment, they said Congress does not, no law can be passed respecting the establishment of a religion or prohibiting the free exercise. It's both and. No established church, if you will, and you have freedom of expression. Okay? But what has happened with RFRA is it does favor established religion. And so I'm really concerned in the coming term of the court, and as we go forward, that what the court's going to do is they're going to probably overturn a very important case. And ironically, it was Justice Scalia who authored it, which is the Employment Division versus Smith case that really says, look, you cannot harm other people basically because of your religious faith. There are generally applicable laws, and you have to make the case, not the state. And all of this is up for grabs right now, and it will harm women as we go forward under this jurisprudence. There is an effort to undermine the Establishment Clause, the separation of church and state. And it's going to favor male patriarchal institutions, which is another way to silence women. Okay? And so it looks really good. It sounds really good. Oh, religious freedom, but it will be used to silence and harm women. And if you look at history, let me just say from the perspective of women, look at history in this nation and globally. It is a very, and I would use the term deliberately, unholy alliance when you couple church and state together in this way, because it harms women and children and the vulnerable who women protect. So we're at an inflection point in our nation on this issue, on First Amendment jurisprudence. And I, really urge our vigilance on this. If you are at all interested in this, I really recommend to you a scholar, a First Amendment scholar, Marcy Hamilton. It's M-A-R-C-I, Hamilton. She's brilliant. She was Sandra Day O'Connor's law clerk. She's a chaired professor. She was at Columbia. Now she works particularly with an organization that protects the rights of children. Here's her quote. If you think I'm overstating this of the harm, it's a great little short quote. Let me just, if I may, give it to you and move to the third point. She said, to this day, there are, and it's true in our nation, and the law often looks the other way. To this day, there are male fundamentalist polygamists in secret enclaves that enslave women, sexually and physically abuse their girls, and abandon their teenage boys. Faith-healing parents stand by as children die agonizing deaths from easily treated diseases. Clergy in many denominations, including Roman Catholic priests, have sexually abused thousands upon thousands of children. To the extent, and here's Marcy's point, to the extent the United States, in its laws, has sublimated the potential risks of religious entities, it has sold out its most vulnerable. This is a whole area where the jurisprudence right now, when you look up at the makeup of our Supreme Court and the particular perspectives of those justices, this is a high risk area for the silencing, and I would say harm for women and those they love and the vulnerable in this nation. And on this one, our founders had it right, and we're moving away from the Establishment Clause. I do not support the Establishment Clause and separation of church and state because I am a non-believer. It's because I respect the rights of non-believers, but also to protect religious minorities and women and those who do not have voices in these religious institutions. Okay, so stakes are really high. Finally, a third 21st century effort to silence women. Are you with me here? I am going, I don't know when you stopped, PM, and I started, but this is my third and final example. I'm just going to give it, if I may, give a direction of where I think we go and then open up for questions.
Oh, do what you need to do. This is great. Thank you. Just keep going.
All righty. So finally, a third 21st century effort to silence women under the law. And that is through what I actually consider this intellectually problematic at best. I would even go so far as to say it's dishonest, which is a stinging critique. I recognize that approach to interpreting the Constitution. And that's the interpretive lens that many currently in our Supreme Court bring to the Constitution, and it's called originalism. If you haven't read about originalism, I encourage you to do that because it will impact all of our lives as women and in this nation. Several of the more purportedly, they say they're conservative judges, they're actually very activist from a particular religious perspective. They're not conservative, they're activists. Justices on the Supreme Court espouse this approach to the Constitution. I just want to describe what it is and why it makes a difference to all of us as women. So they support, look, when you read a Constitution, just like when you read anything, a letter, a book, anything, you have to interpret what it means. And, you know, there are cases in controversy, and the Supreme Court is reading the Constitution. And you'll hear this language, I am faithful to the Constitution. Well, what does that mean, faithful to the Constitution? Many of the originalists purport to support what they call a plain reading of the Constitution, a plain reading of the Constitution. In other words, they're saying, look, read the Constitution. The meaning is obvious. It's plain on the text, and everybody should know what it means. And if something is ambiguous, they go so far to say, well, look, if it's not clear, all you have to do is go look at what the founders intended when they wrote the Constitution originally. So rights and responsibilities under the Constitution are limited to these sources, basically. So here's the problem with this. As a woman, I offer this. This approach to the Constitution is that it's not intellectually honest in the 21st century, given all that we know about theories of interpretation. Some of you who are academicians on this Zoom have probably studied deeply hermeneutical theory. That's the area, the discipline, where you're looking at theories of interpretation. Why? Because there is no such thing, frankly, or very rarely, where there is a plain meaning of a text, because experience itself is interpreted. Okay, so I'm like, you have an experience in your life on this Zoom call. Just whatever it is, call it to mind. The moment you start thinking about it, you are interpreting that experience, and you are interpreting it from your own particularity, whether it is your gender, your economic status, your racial makeup, whatever it is, that influences how you go to the text. So there's no such thing as pure objectivity. So it's a false objectivity. So for example, if I am working from an originalist perspective and the current issues before the court, and this again, remember, I'm talking from the perspective of silencing the experience of women, okay? I look at the Constitution and I bring my own assumptions. Let's say my assumption, and we have several jurists on the court with a very narrow understanding. This is just the fact. They're giving a narrow understanding of their own Catholic perspective. And I'm a Catholic and I differ from them greatly. Okay, they're coming from this perspective, and it's a certain, Bill Barr used to talk about this, the Judeo-Christian vision. That's a 20th century construct. But anyway, he brings it to the text. They bring it to the text. So natural law, what's that? These are creations, and what they're doing is, from that perspective, they fail to recognize, I would argue, liberty interests of women. For example, in their own healthcare or moral determinations, or those of other minorities, religious minorities, or LGBTQ spouses, interracial marriage. Do you realize in 1967, with the Loving case, if those justices were working from an originalist perspective, we would not have marriage equality and interracial marriage today. If you read those cases that predated it, they were originalists. They had horrible quotes from scripture imposed on the law. So this is extremely serious, not only for women, but certainly for women. So for example, with great ease in our current 21st century, these justices will find it easier. They'll look at the plain meaning and say, there's no right to privacy. Read the Constitution. Where is the word right to privacy? Notwithstanding a whole history of stare decisis, previous cases establishing that right in the penumbra of the First and other amendments of the Constitution. Because they take that meaning and they're looking for something and they say, well, it's not there. There's not a right to privacy. That has huge implications for women under the law, huge, as well as for all of us in terms of our own family circumstances, our sexuality, all sorts of things. And it makes it easier for the jurist to disregard actual historical cases in controversy, which developed an understanding of the right to privacy. That's why I say they're not actually conservative. So this is a very, very significant issue. And what's also significant, I'm just going to say this on originalism and why it silences women. Think about the second move of originalism. They'll say, okay, it's ambiguous. So where do we go? Well, we have to stay with what the founders thought. I already gave you that history today and you're aware of it. Those founders certainly would not have been thinking of a right to privacy, would they? They would not have been thinking of women at the time that they wrote the Constitution and their right to privacy, because women were chattel under the law. And if you were African American, you were owned. And sexual violation was a part of the ordinary course of the operation of the plantation. So this is really, really significant. And I would submit that originalism is a wrecking ball for women under the Constitution. I'm very strong on this. This is not, should not be a partisan issue. This is a jurisprudential point I am making. And it will be used to remove rights of women. It is being used to silence women and other minorities. So knowledge, through knowledge, we equip ourselves to defend our democracy. And I believe women are majorly under assault in the 21st century by the law. I've described 3 examples. Procedurally, with Texas Senate Bill 8. I've given you another example of the misuse of the First Amendment, religious liberty interest by getting rid of the balance our founders had, and the theory of interpretation of the Constitution of originalism employed not only by the Supreme Court, but other judges who've been appointed to the court. So the survival and advancement of our constitutional republic require our engagement and vigilance. Now, it's beyond our topic today, but I just want to say one final point, a point of, I think, hope. And if you say, well, Pat, what are you doing? Some of you know I was politically involved. What are the kinds of things I think about in my other work, in my academic work? One of the areas has to do with all of this, and it brings together both theology and the law. And if you're interested in a deep dive into how I think about these things, you are welcome to view my rebuttal to William Barr when he spoke at the Notre Dame Law School, because and it's on YouTube. And why I commend it to consideration is simply it's a deeper dive. And I address our foundings of the nation in the Enlightenment. I address a legal response to him, and also for those of you who are interested in perspective of faith, what I considered his misrepresentation of Catholicism. Jurisprudence, the foundings of our law ultimately have to do with our understanding of the human person. What does it mean to be human? What are our rights and responsibilities with one another? And that's an area I'm very, very interested in. And my constructive work in jurisprudence would submit this to your consideration. We need more women in the law. We need more women on the bench. We need more women politically. We need women voters. We need women clergy. I don't care what religion, what denomination. We need women to bring to voice their experience of all the goodness that they share in the spark of the founders of this nation. We can go back in history and go forward, and all the women who predate us and all the women to come. Women need to be involved, because I guarantee you, as women get more involved, here's going to be the difference. One is we will see that all law, and this is something I have learned as a practitioner, and theoretically, all law is relational, all of it. There is not an area of the law that is not relational. And there's a preoccupation with a lot of male judges, male theorists, male law school faculty It happens at the Notre Dame Law School where I adjunct. They're all preoccupied and wringing their hands about individualism. Actually, we need to pay attention to the relational character of the law, the relational character of the law for a healthy jurisprudence and understanding. And how will women not be silenced? And how will the vulnerable that women love and protect not be silenced? And how will the destiny of this nation be fulfilled? Attend to the relational character. So, you know, I hear this preoccupation about radical individualism. I think it's misplaced. I think the relational reality of the law is where we need to give attention. And rather than individualism, we have to focus on the power of the relationships, which is problematic. And it is through attention to the actual persons in the relationship, in their diverse particularity, that law can be ordered toward the good common to all. I believe we can transform the law that way. So, an example of this, that's why if you've heard me speak on women's moral authority, their constitutional authority over themselves and their bodies, that is not over and against reverence for life. Economic justice is huge in this. Stopping violence against women, giving provision to healthcare. It is a both and all the women I know in their heart and in their practice, most of the ones I know are coming from this perspective. We need that voice not silenced under the law. So I submit that for your consideration today. There's a lot here. I so appreciate all the work of the League of Women Voters and the time with you today, and I welcome your questions.
Wow. Many of the questions in the chat aren't questions. Many of them are agreement comments with you. So I'm just going to talk about the questions, and you can read all of the wonderful comments.
Okay.
And the first one that I find is if Amy Coney Barrett is an originalist, how can she even be on the court or vote on the court or vote in an election?
Well, Amy is an originalist. She's been very clear in her writings and in her opinions. She sat on the Seventh Circuit prior to her elevation to the court. And I was very public objecting to her elevation to the court. There was not appropriate vetting. She's on the court because of the way that the process worked, and that appointment was pushed through, very different than how Merrick Garland was handled during the Obama administration. So she is on the court. She is not the only originalist. Clarence Thomas is one. Samuel Alito is one, as are others. And so that influence is now the majority on the court. And so she's on there. And I think then I step back and say, okay, well, defending our democracy, we have different branches. We have the judiciary, we have, we have Congress and the executive branch. And there are things politically, besides voting, which voting is huge to make sure the right folks are in the positions. We can seek legislation. We can seek review of the number of justices on the court. If we feel that the Constitution is not being appropriately not only protected, but moved forward within our constitutional republic. So there are options of response, but I don't think it's simply targeting and being critical now that this justice is on the court. I think it is looking at it saying, is the Supreme Court fulfilling its duty? There are options under the balance of powers, which our founders brilliantly put in place, which may need to be implicated and called upon.
Okay, I think we're going to go over the 1 hour because now questions are coming in. As long as is that okay with you, Pat?
I am fine.
And as long as and if folks have to leave, they can leave, but I think we'd like to answer all the questions that have come in. The next question is, the original Constitution came out as a culture of white male supremacy. Is supporting those concepts part of originalist theory?
Well, yes, I believe it is procedurally. That is what ends up happening. Because if you are limited to a supposed plain reading the text and then looking from a hermeneutical perspective to what the founders intended, that was the paradigm to which in which it arose. So that is my primary objection to originalism. Now, not all the judges on the Supreme Court at all are originalists, but the way that the court replacements have occurred in recent years, it's not simply we have a political difference here. We have a fundamental difference of understanding of the relationship, I think, of the role of the rule of law, the role of precedent, and also, is the Constitution, what do we understand the Constitution? Is it living or is it not? Sometimes people mock when I say the Constitution is actually a living document. But I'm saying that as a practitioner of law, seeing cases and controversies and working through and expanding. If there's any hope, it must be. I certainly do not believe we are limited to the very narrow moral paradigm of human beings who owned other human beings and could have their way with them in terms of sexual violence without any repercussions under the law.
Okay. In your view, do you need to pass the Equal Rights Amendment in order to ensure legal equality today?
Yes, I think we need to do that. We should have done that already, but I think it is absolutely essential. I think what's as significant as that question, and it's a wonderful question, is we really need to ask ourselves, why in the world in the 21st century do we not have an Equal Rights Amendment? That, sometimes we look at it and say, well, what do we need to do to get there? I think it's as important to be honest and look and say, why in the world do we not have that? And what is the brokenness, I would say sickness, that this reveals about this nation? Many of our European fellow democratic states are way ahead of us on these issues, and they too have their roots in the Enlightenment. So for all that we like to talk about American exceptionalism, we are way behind the curve in many areas, and this is one of them.
Okay, thank you. And what do you mean that all law is relational?
Thank you for that question. All law, what I mean by that is if you look at law, just what does it do? It governs relationships. And I've actually sat and thought about this. I came up with a list. You think about it, every area of the law, you can't practice in the law or be engaged with it and not realize relationships are involved here. Adoptions, guardianships, family relationships. You can look at it, dissolution of marriage, our relationship to property and real estate, our relationship to the ones married, criminal law, the relationship of someone who violates the law, whether it's federal and state. It's all about relationships. Intellectual property, our relationship to our creative genius. Who has rights to that? It's all relational. And why I emphasize that is because when you go to the law schools and you hear what they're debating, or you look at these judges' opinions, there's a real, hand wringing because, oh my God, women are gaining power. Oh my God, minorities, religious minorities, or people of color, or others are gaining power. And they're hand wringing saying, well, the problem is individualism. And they really get, if you look at the opinions of the court, they get very distressed when it has to do with matters of sexuality. My point is, when I say all law is relational, if you really want to have a healthy understanding, I say jurisprudence, a healthy understanding, an anthropology, an understanding of the human person, which informs the law, you have to recognize that law itself is relational, and this hand-wringing over individualism is not the point. Look at how law either fosters healthy relationships. It's really quite simple. It's similar to the oath that the physician takes, do no harm. The oath I take as a lawyer, do no harm. I have an obligation to foster relationships which are life-giving and good. And I think we need to look at power in those relationships. And the more we attend to that, the better the jurisprudence will be. And that's why I say it's relational. And most of these persons who are freaked out about the advancement of sexual minorities, for example, or women, are people, frankly, with their own issues from a psychological perspective on human sexuality. And it needs to be named. And it's not generally women who have these issues. White, male, affluent, property only persons. Look at our founding and the contradiction in the founding of this nation. That contradiction still exists today in the 21st century, and it's tearing at the heart of our constitutional republic.
Very good. Thank you. Another question. How do you remain, excuse me, how do you remain an optimist, given your understanding of history and your observations about the ways that racism, misogyny, and greed continues to shape so much of our politics today?
It's a really good question. I think at this stage of my life, I would say, well, first of all, dispositionally, I was sort of as a person, I was always fortunately optimistic. That's just honest. I was okay, keep going. I was very fortunate to be in a situation of love and support in my life. But I've had enough knocks and things losses in my life that I would have to say that the primary reason I am an optimist on all of this is because of the example of extraordinary people that I have had the privilege of sharing life with, and that their love and their devotion, even in the experience of death, is I have personally had the experience that death does not have the final say, that brokenness and violence does not have the final say, and that I know to my core that this nation and the things we're talking about are part of something very good and mysterious and lovely and holy. And I believe that. And so my optimism comes from the example of extraordinary persons of love and intellectual integrity and a call to something better. They modeled for me, I said I'm theologically trained, I'm legally trained. They modeled for me that justice and love are really the same. They're really the same. They're not different concepts. And I want to be about that because at the end of the day, philosophically, my optimism, I recognize at the end of the day, I think the choice is nihilism and it's all absurd, or there's something magnificently purposeful here. And I plant my flag on that magnificent purpose because of the example of people integrity and goodness.
Oh, if we all could plant our flags that way.
Well, I lose sight of it just like anybody else. And I get silenced and sidelined and frustrated. And that's when I better go for a swim or something and get it out of my system. Because it's like, I'm like everybody else. It's hard. And we're in a hard moment in history right now.
Yeah. Sorry. Can you clarify neo-feminism?
Neo-feminism? No, I don't think I can because, I would think that probably somebody, if April's still on, might be in a better position to do that. I certainly understand feminism, but neo-feminism and how that's been used, I think that's something I would have to do some research to see how it's being used, because you can have a term like that and it's used in different contexts. It's not something I identify with or is central to my own thought. And so I don't want to mislead on a response on that. I can surmise, but I don't want to do that.
Yeah. And April's gone. She said she was going to watch this. She's going to do the recording. Next question. They keep coming more and more. What do you say to people who say, quote, but separation of church and state is not really in the founding documents. It was actually in a letter from Thomas Jefferson to the church in Danbury, whose congregation was worried that the future of religious beliefs were in peril, unquote.
I say that that's not correct. I think that if you look at the language in the First Amendment of the Constitution, it is a both and. It is no law shall be passed in support of the establishment of religion. That establishment clause and all the jurisprudence which has come from that is the separation of church and state. And then the other part, the free exercise, is the free exercise of religion. Now, I would concur with whoever asked the question that sometimes the separation of church and state can be overstated, but there is no question that if you look at both the historical circumstance, the founding of the country, people were fleeing religious oppression in Europe. That's a big part of our founding. And in the text itself, it didn't say free exercise. It says freedom from the establishment of religion. So I don't believe that it's too simple, I think, to just say, well, the separation of church and state comes to there. I think of separation of church and state as a shorthand way of preventing against the tyranny of religion. And the tyranny of religion is real. And that's my concern for women and the vulnerable, and actually the survival of democracy. I just give you another example. If you do listen to my William Barr rebuttal, in the last part of that, I talk about the fact historically, in more recent history, prior to World War II, the very, very dangerous alliance in Western Europe between church and state, very analogous to William Barr's worldview, that led to the rise of fascism and authoritarianism that should have no place. So it plays a very powerful political role. It's how Putin uses the Orthodox Church right now in Russia. And there are politicians in the United States right now who are using that playbook of the extreme religious right and that authoritarianism that leads to. So this is a very, very dangerous force that our founders experienced. They put it in the Constitution, and we have very healthy jurisprudence, which is being undermined right now and weakened with the current court and RFRA.
Okay. And our last question. Oh, there's two new messages. I hope they're just messages and not questions. Here's the last question. Can't one be a conservative activist judge, just as one can be a liberal activist judge? This has many parts to the question. That's the first part. Oh, I'll tell you the rest of it then. People conflate activism with liberalism and with loose construction, but isn't judicial activism the opposite of judicial restraint, deferring to popularly elected branches of government, while liberalism is the opposite of conservatism and loose construction of the opposite of strict construction? Can't decisions fall into different combinations of these three dimensions?
Okay, that's a very complicated question. I would say that you can have activist judges on each end of the spectrum. Well, you could say, and I think labels like conservative and liberal can be misleading. So there's that. You can have activist judges on either end of the spectrum. I think the healthiest court is not activist on either end of the spectrum necessarily, but is well rooted in theories of interpretation that are informed by the actual development of the law in history. I have a high regard as a practitioner of law of stare decisis, actual cases in controversy. And at the end of the day, the way we get through this and find common ground are the building blocks of the rule of law, and that is reason, evidence, and science, and the application of the law. Every case I take to court, reason, evidence, and science, and laws applied to that circumstance, and that's how law develops in a good conservative way, but also progressive way through history. So that's a simplistic answer to a complex question, but I would just recognize I'm saying activism on either extreme is not helpful, especially at the highest court, but we have to pay more attention to reason, evidence, science, and the development of the law in history, and not be naive in our approach to the Constitution itself. In other words, do not equate originalism with fidelity to the Constitution. It is far from it.
Pat, thank you very much for a wonderful talk.
Oh, you're welcome.
And thank you for being willing to share for past time. This is probably one of the few times that we've run over like this. So thank everybody for staying in here with us. And thank you so much for all the wisdom that you shared with us today. It has been wonderful.
Well, you are very welcome, Pam. And if anyone wants to follow up personally with me, I'll give you my email. It is Hackett. There are two T's in Hackett. Hackett at Hackett Associates. That's ASSOC.com. That's my email at my firm, and I will try to get back to you. If you want to give me a phone number in your email, I may call you. Sometimes I prefer to call as opposed to lots of time typing. I welcome ongoing conversation or insights from all of you. This is all our collective effort and our collective love of our country. So thanks, Pam. I appreciate the questions.
You're very welcome. And if you'd like to just run through all the wonderful things people said about you and comments that they made.
Thanks.
But anyway, it has been recorded, and it will be available probably by next week sometime, both on Facebook and on our webpage. And thank you, everybody, for taking part today. And thank you once again, Pat, for your wonderful presentation. Thank you all.
Thanks to all of you for all your hard work. Take care.
Thank you. Bye.
Bye.
Have a good day, everybody.
Yep. Bye-bye.
Bye.